Good day. Welcome to this edition of Practice Ready Evidence. Wherever you are, I greet you digitally. I want to discuss Article 6 today, and I want to talk about 607 through 615. I want to zero in on those specific evidentiary rules that deal with witnesses, their presentations, our expectations, what we should or should not see. You should think of the Article 6 rules as rules that apply to anyone who takes the witness stand at trial, regardless of their status otherwise, as either a party or a non-party. We are concerned with some specific issues when you testify, those generally rotating around competency, capability, and credibility. Let's get started. When we look at Federal Rule of Evidence 607, it tells us that any party may impeach any witness and that vouching is no longer an issue. If you grow up in the federal rules of evidence as they exist today, you might think, well, what is the purpose for the existence of this rule? This rule exists because it used to be at the common law that you could not put a witness on the witness stand if you weren't vouching for their credibility. Well, what did that mean? It meant that I could have a witness with credibility issues, but I couldn't diffuse that credibility by talking about it and drawing the sting before the cross-examination. And it meant that the lawyer often would edit and remove witnesses from testimony because they had a credibility problem. And the federal rules of evidence, of course, flip that. Now I can, of course, put a witness on the stand and, to the extent necessary, impeach them myself about any issue that may be out there regarding their credibility or their bias. If you'll think about it from a government lawyer's perspective, dealing with snitches, dealing with co-conspirators, there was a real necessity to be able to do this, and it changed, fundamentally changed, the way in which we present witnesses because it expanded the range of what was possible. And Article 607 is just the codification of that shift in policy from a witness presentation perspective. We go and look at 608, and 608 is a rule that for many law students is troubling. And for lawyers, they don't often understand it, and they tend to conflate Rule 608, character for truthfulness, as it applies to a witness on the stand, with Rule 404A, character of the victim or the accused or the plaintiff or the respondent, when they're not dealing with the same thing. Under 404, it has to be a pertinent character trait relevant to the cause of action or to the defense that's raised. 608 deals purely with the credibility of the witness on the stand. And what it does is it gives us a rubric for when we are allowed to impeach based upon truthfulness or untruthfulness and the methodology that we need to use for truthfulness or untruthfulness. And what 608 tells us is that I can attack the credibility of any witness once they have testified, once their testimony has been accepted for the truth at trial. And I can attack their credibility by cross-examining them on specific instances of conduct where they were not truthful, or by calling other witnesses who have knowledge of the witness that's already testified and eliciting reputation or opinion testimony about the truthfulness of the witness who's already taken the stand. There's a couple of caveats on this. I can do specific instances of conduct on cross. I can do specific instances of conduct to rebut on redirect as to the truthfulness of the person in question. But what can I not do? I cannot bolster the credibility of a witness before they testify. So let's say I have witness X, and witness X is going to testify at the end of my case in chief. But I've got witnesses A, B, C, and D, all of whom know witness X, all of whom have an opinion as to witness X's character for truthfulness, but because X has not yet testified, it would be improper bolstering for those witnesses to take the stand and talk about that individual's credibility. The other thing that we really need to remember when dealing with character for truthfulness, it's of a witness, not a party. So their truthfulness is always a collateral matter. And when I say it's always a collateral matter, what that means is if they lie about being a liar, I'm stuck with the answer. I cannot offer extrinsic evidence of proof about the untruthfulness of the witness because it's collateral to the cause of action in the case. It might be interesting, it might be fun, but it can be terribly confusing and a waste of time. So we're stuck with the answer that the witness gives us. Now, witnesses don't often realize this, and there are many ways to work around this restriction, from a persuasion modality, from a presentation of impeachment at trial, where you can walk right up to the edge without actually admitting the document that proves the extrinsic untruthfulness. But from a fundamental law perspective, you just can't go there. You're not allowed to prove that they're a liar if they lie about being a liar. And this is the only method of impeachment where extrinsic evidence that's otherwise admissible is not allowed. And so that makes it fundamentally different. It means that people like to test on this on the bar examination all the time because folks get it wrong. And it means that it creates confusion between 608 character for truthfulness and a 404A theory of character propensity where the door's been opened. And so you have to be aware of those particular modalities when you're dealing with it and make certain that you identify it properly. If you sort it the right way, the law is not too terribly difficult to apply, but you have to listen with specificity for the character trait in question, and you have to know the status of the person on the witness stand. And if you don't understand that their status is that of a witness and not a party, you could inadvertently get that 404 versus 608 question wrong. 609, on the other hand, is one of the favorite rules for lawyers and one of the least favorite rules for convicted felons. We think, from a societal perspective, that if you have been convicted of a crime in court, the fact that you have been convicted, the knowledge of your conviction, is a pertinent issue as to your credibility as a witness. And Federal Rule of Evidence 609 sets up the gates in determining when your prior conviction is or is not admissible at trial. So, for example, there are two primary types of crimes that are potentially admissible for impeachment purposes as to credibility. The first are felony convictions. And felony convictions are any conviction for a crime that could potentially result in more than a year of incarceration. A felony conviction is admissible for impeachment purposes, subject to the 403 balancing test. And that works for the first 10 years after the punishment for the felony is complete. So, if you were convicted of a crime, you got a sentence of 10 years, and you served 6 years in prison, and then you get out early on parole, you had 4 years of parole. It would only be at the end of the 10-year sentence that 10-year clock begins to toll under Federal Rule of Evidence 609. So it makes the application of the felony rule a math problem, and we all know that most law students are in law school because they don't like math. And judges don't like math, and lawyers don't like math. This issue comes up all the time on the multi-state bar examination as a result, because they can easily draw lines. So for felony convictions, 10 years after the end of government control is how you apply it. And for those first 10 years after the end of government control, it's a 403 balancing test to determine admissibility. After those 10 years, it's deemed to be inadmissible, but you can make a motion to try to be allowed to impeach on it. And when you impeach in federal court on a conviction that's admissible, you're allowed to confront the witness with the fact that they're a convicted felon and also cross-examine them on the type of crime that they were convicted for. And you are allowed to admit the record of the conviction itself into evidence. The jury can then consider it and peruse it as they determine the credibility of the witness. That's remarkably different from state courts such as Florida. In Florida, you can ask them if they're a convicted felon, but you can't even confront them with the nature of the crime, and you cannot introduce the underlying documentation unless the witness lies about it. And if the witness lies about being a convicted felon, then you can confront them with the crime for which they were convicted, and you can admit into evidence the document itself. So we reward convicted felons who don't lie about being convicted felons by not embarrassing them in front of the jury with the nature of their crime. Now, the other type of crime that is admissible at trial are crimen falsi crimes. These are crimes that have some element of falsehood that's intrinsic to their nature. Think false statement, false swearing, perjury. When you're convicted of a crime like that, it doesn't matter if it's a felony conviction or a misdemeanor conviction. For the first 10 years after the end of government control, the end of your sentence, including any probation time, this evidence is admissible for impeachment purposes, and the judge cannot exclude it under a 403 balancing test analysis. We are so sure that the jury, knowing that you've been convicted of a crime of falsehood, is relevant to their determination of your credibility, that we're going to let it in without challenge in that first 10 years. After 10 years, it's going to be admissible subject to a 403 balancing test. So you've got two types of convictions here: crimen falsi crimes, both misdemeanor and felony convictions. They have a separate balancing test, a separate application test, and there's some hard and fast rules from a timeline perspective. It means that these rules are ubiquitous on the multi-state bar examination, even the uniform bar examination, because they are ultimately confusing and difficult to apply. The other thing that you also have under 609 is if the witness is the defendant in a criminal trial and you're trying to cross-examine the defendant about a prior conviction, you have what I refer to as a reverse 403 balancing test. The prejudicial effect of the jury knowing about the prior conviction is presumed to be true, and the probative value has to outweigh that prejudicial effect. This means that the field is tilted against admitting the conviction of the accused in most instances. Sometimes, though, that conviction and the underlying facts might be admissible under a 404B theory of relevancy. And you'll see instances where the facts are sort of extracted from the conviction and admissible in a separate line. That does happen from time to time, but that's a separate question from the 609 analysis. We actually have a federal rule of evidence, Rule 16, which tells us that evidence of the religious belief or opinions of a witness is not admissible to attack or support the witness's credibility. In other words, you cannot argue that a witness is more or less likely to be truthful because they happen to belong to a particular religious sect. But it might be admissible for another impeachment reason. What pops into my mind almost immediately? Bias, prejudice, motive to lie under the common law. This idea that your relationship forged through a religious bond might make you more inclined to shade the truth in favor of someone who shares your faith or against someone who doesn't share your faith. This is a really fine line, and I would recommend to prosecutors in particular who are thinking about inquiring from an impeachment perspective on religious belief or opinion, that you do this in camera with the judge ahead of time, that you get a specific ruling as to its relevancy and the way in which you present it, and that you're very careful to stay inside those lines, because if you get outside those lines, you're going to have a mess on your hands, both politically and professionally. Now, Rule 611 is a rule that defines the questioning modality for direct and cross-examination. It's the rule that captures the common sense narrative that we teach in trial advocacy classes about open-ended questions on direct examination, the ability for closed-ended questions on cross-examination. And it's a restatement of that common sense, but it also identifies and clearly states that the judge has the ability, the court controls the format and the method of questioning. And this is to avoid wasting time, to protect witnesses, and to keep us all on track. This means that with a child witness, the court can be more lenient if you need to lead. With a witness of diminished capacity who nonetheless has competency, it allows for the court to make the method of inquiry from a questioning perspective fit the circumstances of the witness. And now that's phenomenal power that's placed in the hands of the judge. We draw from this rule as we establish how we function, how we process from both a direct and a cross-examination perspective. We use it as we think about working with child witnesses whenever we want to ask the court for some leeway when dealing with a witness who has a capacity or a presentation issue. And it also informs our thought process and connects to, quite frankly, Federal Rule of Evidence 104 that delineates the authority of the judge to determine the admissibility of witnesses and the way in which it works. It's a rule of procedure. It's a rule of form as to the formulation of questions. And it's something that anyone who's been in a courtroom or questioned a witness should know. But it's amazing how many people actually don't see the connection between this and our common sense practice of the law. Now, Federal Rule of Evidence 612 is a rule that allows you to refresh memory. And it's often connected to Federal Rule of Evidence 8035, past recollection recorded. So let me talk about Federal Rule of Evidence 612 for a minute. When I have a witness on the stand and they remembered something previously, and while they remembered it, they wrote it down, they recorded it in some fashion. And now, under the stress of trial or the time having passed, they no longer remember that fact with specificity. I can lay a foundation to show that the witness knew it previously and that when they knew it, they recorded it. So I'll say, ma'am, have you had an opportunity to write down that serial number previously? Well, yes, I have. Well, when did you do that? I did it about a week before the item in question was stolen. When you wrote down the serial number, how did you do it? Well, I looked at the piece of stereo equipment and I wrote the letters down one at a time. When you wrote the letters down, did you know that serial number? Well, yes, absolutely. Would looking at the piece of paper that you wrote it on refresh your memory as to the serial number of the item in question? The witness says yes. I can hand the witness the document that it's written on. They read it silently. I say, read it silently to yourself. Look up at me when your memory's been refreshed. They look up. I bring the document back to me, and then I say, and what was that serial number, ma'am? If she can recite it from memory at that point, her testimony is admitted into evidence. If she still can't remember the numbers, and this often happens with serial numbers on bills, counterfeit bills, on documents, bills of lading, things like that, I then give her the document back again. And I lay the foundation to show that at the time that she recorded it, she knew it. And then I offer that portion of the document into evidence under 8035, past recorded recollection. That's an interesting thing, because when I refresh memory with one piece of a document, or I admit memory under a past recorded recollection exception, the opposing party, the adverse party, has the ability to inspect the writing, to cross-examine on it, and to potentially admit other pieces of it under Federal Rule of Evidence 106 Rule of Completeness. And so there's lots of things that happen when I'm refreshing someone's memory. I'm utilizing 612, I may be utilizing a relevant hearsay exception, and I may be looking at admitting other portions of the document that might not otherwise be admissible under a hearsay exception under the Rule of Completeness. So there's a lot going on there, but if you step back from it and think about it practically and rationally, it just makes sense. If you knew the number or the information when you wrote it down and you subsequently forgotten it, if we can validate that you knew it at the time, all it really is a writing that captures your memory at that moment in time. And that's sufficient and that's admissible. So we're really not worried about it. Now, Federal Rule of Evidence 613 is often referred to as impeachment with prior inconsistent statements. We are allowed to confront a witness who testifies under oath, subject to cross-examination, with any factual inconsistency between their in-court testimony and what they've said previously. It doesn't matter the format or the nature of the prior statement, as long as it's recorded so that we can confront them with the inconsistency. We have to disclose the prior statement to opposing counsel, but there is no requirement that we show it to the witness before we cross-examine them on the inconsistency. There's no requirement that we do that, although sometimes we do for effect. But doing something for effect and doing something because you have to are two different things. Now, that extrinsic evidence is being used to challenge the credibility of the witness, to say that they are not being truthful on the stand today. That's a limited purpose. We're not admitting that prior inconsistent statement to say that it is true. In fact, we can't unless we have a hearsay exception that allows us to admit it, that vouches for the validity, the credibility, the indicia of reliability on the truthfulness of the out-of-court statement. If we can fit it into that out-of-court statement, we then get a 2-for-1. We get to confront with the inconsistency to attack credibility, and we get to admit the earlier statement substantively. It's beyond the scope of what I'm talking about right now, but later on, when you're viewing some of the presentations on hearsay evidence, particularly on the 801 exclusions, it connects back to prior statements by witnesses. The important thing is that the witness is given an opportunity to explain or deny, and that the adverse party gets to examine the information before I cross-examine them on it. The rest of it is in the presentation, and I would refer you to some of the trial advocacy videos to take a look at that. Federal Rule of Evidence 614 talks about calling an interrogation of the witnesses at court, and this rule is just there to remind you that while counsel can call witnesses, the judge has the ability to do so as well. And if the court calls a witness, has an independent witness of the court, both sides have the opportunity to cross-examine. And so that's what 614 really does for us. That's what it tells us. And then the last rule that I want to talk with you about today is Rule 615, and that's just exclusion of witnesses. The exclusion of witnesses rule is nothing more than a rule designed to prevent cheating at trial. In other words, if you're going to testify at trial, we're not going to let you watch the trial before you testify, because that might in some way impact your testimony. The exceptions are the parties, a designated representative, or someone who's essential to defending a claim or presenting a claim. You should think expert witnesses here, right? And then in some instances, a person authorized by statute. You might think victims of assault, where we have a statute that allows a parent or a loved one to be present in the courtroom. So these are our Federal Rules of Evidence 607 through 615. They deal with procedural aspects of the presentation of witnesses and primarily attacking a witness's credibility for purposes of arguing that they should not be believed from a credibility perspective by the jury. You should remember that the jury is, at the end of the day, the ultimate arbiter of credibility when it comes to a witness's testimony. And these rules can be extremely powerful tools for convincing the jury to ignore what someone's just said. Till next time, I'm Charlie Rose, and this is Practice Ready Evidence.